All right, now we have our next video, and we're going to look at some recent cases on respecting reasonable expectations. These cases concern retroactively updatable contracts. So let's get started. So reasonable expectations in retroactively updatable contracts is our topic. We just finished in the last video talking about retroactively updatable contracts, and we noted that there had to be some limitation on what terms you can change, and now we have two cases that directly address that question. These are the key leading cases right now in retroactively updatable contracts online, and I'll tell you right up front, we have a disagreement between the cases that is yet to be resolved, although in my opinion, one of the cases is correctly decided and the other goes in the wrong direction. Still, as far as case law goes in the various jurisdictions, there is a difference of opinion. So let's get started. Recall our treatment of reasonable expectations. There are three sources of reasonable expectations. We took that from Stephen, our Stephen case that we discussed much earlier, right? The courts use a three-part test to determine reasonable expectations. They look at the type of transaction, they look at the reasonableness of the business practice, and they look at the words of the agreement, the words of the contract. Now note, as you see in the box outlined in red, the cases we have are going to talk about the obligation of good faith and fair dealing. As we noted earlier in our videos, in the consumer contracting context, that's the same as talking about respecting reasonable expectations. Now, since the cases talk about the obligation of good faith and fair dealing, I'll generally talk about the requirement that way, not as the requirement to respect reasonable expectations, but they're the same. And our three-part test that you're looking at, of course, came from our discussion of the Stephen case earlier, which talks about reasonable expectations. Okay, so that's just by way of terminology so that there's just no confusion about do we have two concepts or one concept. We have good faith equal reasonable expectations. So our first case we want to look at is Beatty versus Bank of America. Bank of America is a large bank in the United States, and Beatty had an account with Bank of America. And at this time, Bank of America was sending paper mail statements each month to its account holders. They hadn't yet gone over to electronic statements, and indeed, many banks in the US still aren't totally, haven't totally switched to electronic statements. But they were sending paper mail statements to their account holders every month with the information about the, the withdrawals and deposits and charges and so on in and out of the account. And since they're sending out the paper mail statement, they typically would include other things in the statement, often advertisements, announcements about what the bank is doing. And on one occasion, they included a notice that they changed their retroactively updatable agreement with the account holder. Right? So in addition to the advertisements, government required notices that the banks have to send out and other offers, advertisements, bank policy. And this time they stick into the envelope, gee, by the way, we've changed our retroactively updatable agreement. And what they did was take away the right to go to court to sue the bank and substitute the requirement that account holders, when they sue the bank, submit the dispute to alternative dispute resolution. In other words, to arbitration or to mediation, right? Alternative dispute resolution is one of those two. Alternative dispute resolution, often referred to as ADR, if you see that. So that's the change in the contract. The notice they send out is just in the paper mail statement, and the bank says, as the court notes, the bank decided that, well, this is not a problem, right? We have the right to do this because just like Purdue, In the Purdue case, I mean, and just like the Purdue case, the bank, Crocker National Bank in the Purdue case, just like in the Purdue case, we put the right to make this change in the offer itself. Right? So when we make the change, that change is not a new offer that needs, that the account members can accept or reject. It's just a change in the original existing contract. And that change is retroactive, covers all of our relationships with our account holders from the beginning, right? So, I mean, if they get sued on some event that happened before the change was made, even that dispute has to go to alternative dispute resolution. So that's where that. So the Bank of America comes in when Beatty sues them. Beatty says you can't do this, right? It's interesting. I've never been able to find out why would Beatty sue. I'm going to understand the dispute, obviously, but it's expensive to sue. This must have been a lawsuit funded by some consumer organization that was paying the bill, because this would be expensive for an individual account holder to fund this litigation, hundreds of thousands of dollars. So, but anyway, we don't care, right? What we care about is that the suit occurred, and we care about the doctrine. But just noting in passing, it would be interesting to someday to do the research to find out, well, exactly why did Beatty, exactly how was Beatty paying for this? Anyway, let's go forward. So I note, by the way, it doesn't matter in this case. I note that there was no cancellation clause in the account between Beatty and the Bank of America. There was no clause in the account, in the contract with Bank of America that says, account holder, if you wish to cancel your account with us, here's the procedure. That makes no difference to this case, but the next case points to that difference as the key difference between it and this case, Beatty. So we noted in passing here, we will return to it. And a note in passing, probably there was no cancellation clause because there was no need for one. There was already a procedure for closing accounts at the bank. You walk in and say, I wish to close my account, and you can close out the account. And then then the contract is just null and void. There's nothing for the contract to govern once the account is closed. So I assume that's why they didn't put it in. Makes no difference here, as I said, big difference, big point in the next case we discuss. So we got it. So to summarize, our case looks just like the case in Purdue versus Crocker National Bank, right? We've got a change in the contract. The bank gets sued, the bank defends. So no, not a problem. We have a right to make that change, right? So and the bank is right, provided that we know from the Purdue case, the bank is right, provided that that change is consistent with the obligation of good faith or fair dealing, or as we've been saying, with the reasonable expectations of the consumer. And we have a three-part test for that from Stephen. So what we're going to do is apply that test to Beatty and to examine the decision in that way. The Beatty court does not explicitly refer to this test, but their discussion organizes itself in exactly this way. Right? So I take it Beatty too is applying this same three-part approach. So let's do it. So our first part is, as you see on the slide, type of transaction. So what can we say about the type of transaction in this case? Well, it's a consumer bank transaction. We know consumers don't read and would not understand the contract. And in this transaction, the key thing that impresses the court, in this transaction, the bank reserved to itself the unilateral and non-negotiable right to vary every aspect. And this is what really causes the problems for the court. Every aspect of the performance required by the parties to the account agreements. So the court says, look, okay, this is the consumer bank transaction. We know they don't read and wouldn't understand those. We made that point very early on when we were discussing unconscionability, right? That's standard point about consumer contracting. And in this one, notice what they said in the retroactively updatable contract. we can change anything, right? And that bothers the court quite sensibly, right? If I said, right, if I said, I respect your reasonable expectations concerning our contractual relationship, but I reserve the unilateral and non-negotiable right to vary every aspect of what I promised to do, would you trust me to respect your reasonable expectations? You'd have not normally no, right? If I say, gee, I just promised to do X, but of course I reserve the absolute right to change my mind to do X anytime whatsoever, you'd say, well, your promise is worthless. Right? That's what bothers the court. And indeed, the court says that this alone is enough for lack of good faith. The bank's interpretation of how broadly it may exercise that right to make changes, the one we were just discussing, with no limitation on the substantive nature of the changes it may make, right? This is we reserve the right to change anything, right? Required by every right to no limit. Oops, sorry, I hit the button in it by mistake. With no limitation on the changes that we make. It may change anything as long as it complies with the de minimis procedural requirement of notice, by which they mean, look, the bank says, well, we told them we made the change. They sent a piece of paper in the envelope in the monthly statements. Then we all know what happens to that piece of paper, right? Nobody reads it. Of course, you toss it away. That's just like the contracts. Nobody pays much attention. Maybe a few people do, but almost nobody pays attention to that. And the bank knows that. That's why it's de minimis notice, right? Tiny, inconsequential, not meaningful notice. The court says that virtually eliminates the requirement of good faith and fair dealing from the bank's relationship with its credit card account holders. So just by the nature of the transaction alone, the Beatty court says, gee, this doesn't look like respecting reasonable expectations, good faith to us. And we will go on to the next two factors in our test for reasonable expectations. But before we do, it is worth pausing to note that every online agreement looks like, almost everyone looks like the one in this case. This is the New York Times, right? As I said, an excellent example. Look what it says. We may change, add, or remove portions of the service at any time, right? Any portion, right? The way that's written, that means we may add or remove any portion of these terms of service at any time. In other words, we can change anything. That's just what the Beatty court said too. And if you look at the online terms of use agreements you enter, at least the well-written ones, this is pretty much what they'll say. Sometimes they say we will, if we make any material changes, any big significant changes, we'll let you know. But typically they just say this. And then we have the problem. I just repeated the slide for convenience. If you say that, we have the problem, the court notes in Beatty. Well, but this looks like a loan. This eliminates the requirement of good faith. This eliminates it, inconsistent with the requirement of good faith and fair dealing. That's required of relationships with their account holders or consumers, generally readers in the case of the New York Times. And so there's a puzzle about contracting practice, and the puzzle is deepened by the fact that it is very difficult to impose limits on the right to make changes. Now, the way to, here I think is best, the way to think about this is imagine yourself as the lawyer for the business. Don't imagine yourself as the consumer or the lawyer for consumers defending the rights of consumers. put yourself in the position of the business lawyer or the business and think about the problem they face, right? As I point out, as we discussed earlier in the LinkedIn example, illustrating how big the changes can be that businesses want to make. And your problem as the business lawyer is to give businesses the right to make even the significant changes in their retroactively updatable contracts that they wish to make. That makes it extremely difficult to write in a limitation here about only to restrict the changes that can be made here, because you don't know in advance the changes your client will need. So I assume that's why they get written this way. And that gives us the both theoretical and very practical problem of exactly how to interpret these. Should we go with the Beatty court and say this alone is evidence of lack of good faith and fair dealing? So there's the LinkedIn example again, just to remind us of how big the changes were. So let's look at so that's our first type of transaction. So type of transaction, when we look at in Beatty, counts heavily against thinking that the bank's position is consistent with the obligation of good faith and fair dealing. What about the reasonableness of the business practice? Now, remember compare Stephen, when we discussed think back to our Stephen case, the poor man that died in the plane crash and the insurance company doesn't want to pay off on the life insurance. There was really, the court couldn't figure out why the business practice was reasonable. Why won't you insure when the person flies on a substitute carrier in an emergency, right? Why do you say, well, we can't insure for that? And the insurance company never explained. So that was a pretty clear case of a lack of an explanation of the reasonableness of the business practice. We don't have that here. Here we have, from a business point of view, a pretty reasonable business practice. Businesses want alternative dispute resolution, binding arbitration, say, or mediation. That's a very reasonable business practice for the business. It makes their legal liability a bit more predictable. It's because the process is faster. Arbitrators tend to be a little more favorable to businesses on the whole. It's cheaper, and for the business avoids class actions, right? Because arbitration is one by one. So there are pluses for the businesses. There are minuses for the consumers, the customers, right? You lose your right to go to court, and right now is the way arbitration is treated in the US. It's one by one by one. You can't join together in a group of consumers and go to arbitration, so no class actions, right? That makes it difficult to fund litigation against a business where they do something to consumers, as a whole. And the right we're talking about is a very substantive one. You have a constitutionally protected right to a jury trial in the United States, and they're taking that away. So both in terms of fundamental justice and in terms of, gee, is this really good for consumers, customers? It's far less clear. The counter argument that it's good for consumers is, well, but if you go to arbitration, it reduces the cost of running the business because legal liability is less and more predictable. And that can benefit consumers as businesses can lower their prices and consumers benefit that way. But we have a less clear situation. The court doesn't try to resolve, whether it's good or bad for consumers in this way. They take the position, this is a very major change, primarily because of this. And they say, this is a very major change. Yes, you can make a major change this way, but you have to give effective notice to consumers. You have to tell the consumers in advance, hey, we are making a really big change to our contract, and we want you to let you know that well in advance so you can decide what you want to do. And the court holds the piece of paper in the envelope did not rise to that level of notice. So that's how they handle this. They combine the reasonableness of the business practice test with a notice requirement. Yeah, you can make big changes that favor you and maybe don't favor consumers so much, but you must give very effective notice. And that leads to the question in the slides, which is unanswered. Exactly how much notice, how far in advance, and what form it must take, that is yet an unanswered question. Same point, and by the way, I put in the slides, we didn't discuss it in Stephen. The Stephen case actually makes the similar point about the role and possibility of notice. So let's turn to words of the agreement. Right, that's the last part of our test. Type of transaction favors finding a breach of the obligation of good faith and fair dealing, or lack of reasonableness. Our second test, reasonableness of the business practice, turns out that this court says, well, you failed the notice requirement that would be needed for the kind of major change you want to make, so that counts against the bank too. And then the words of the contract. And this is a particularly important point for our next case, right? The court says, our focus is on whether the words of the original account agreement, the one before the change, mean that the bank's customers, by agreeing to a unilateral change of terms provision, this is the right to make changes that's put in the offer, intended to give the bank the power in the future to terminate its customers' existing right to have disputes resolved in the civil justice system, including their constitutionally based right to a jury trial. So they ask, and so in short, look, we're going to read the contract and we're going to decide that whether an account holder reading that original contract would think, well, I'm agreeing to let them make a change as big as taking away my right to go to a jury trial. Or would they think they're not agreeing to that? So they read the words of the contract and ask, what reasonable expectations about future changes would that generate, right? So let me again. Here, they find that here, as in Stephen, they find the contract ambiguous on this point. They say we could read it either way, right? So that doesn't play much of a role in their decision. Well, it does play a role, but not much of a role in their decision that there's a inconsistency with the obligation of good faith and fair dealing, inconsistency with respecting reasonable expectations, because they say the contract doesn't decide that question one way or the other. But since they've already found an inconsistency in the first two tests, they come out thinking that the bank is inconsistent with the obligations of good faith and fair dealing. Okay. So good, yeah. So here we go to summary. This was our type of transaction inquiry. You come in and say, I have an unlimited right to make changes in the contract. That itself is inconsistent with the obligation of good faith and fair dealing. If I'm going to make really big changes require conceptual notice. And in this case, the contractual language, the court doesn't address the weight of unambiguous language. We don't know yet, what would happen if the contract language went one way or the other. How's the court going to handle that? We will see that in the next case. But this is Beatty, and Beatty was very shocking news to the business lawyers, right? Beatty is not good news for the business lawyers. Remember the problem the business lawyer has. Business lawyer's problem is to write a retroactively updatable contract that gives the business the freedom to make the sometimes quite major changes it wants to make. Right? And so we get, let's go back to the New York Times. That's why we get contracts like this, right? This gives the business the right to make virtually any change it wants to make, right? So that is the lawyer solution. Now, that was the lawyer solution. That's why all your online contracts read this way. And then Beatty comes along and says, well, gee, if you say this, that's inconsistent with the obligation of good faith and fair dealing. And if you want to make a really big change, you have to give conspicuous notice to consumers. Now so the first point's pretty clear. That's not good news if you're a business lawyer on the side of the business. The second point sometimes doesn't impress lawyers, but it's bad news for a business, right? If you're trying to sell things, you don't want to rub people's noses in the fact that you're taking away important legal rights or making big changes that may not be favorable to them. Think about it this way, right? If you're running, suppose you're running a physical store. What's about the last thing in the world that you'd put at the entrance to your physical store? A lawyer. A lawyer coming in, the person walks in the store, a lawyer jumps in front of them, says, terms and conditions, read before entering. No, we don't do that. That people will just turn around and go to another store without the lawyer that jumps in their face. Businesses don't want legal terms jumping in the face of their customers. They want to make it as easy and as pleasant as possible to do transactions with them. So the big notice requirement is not good news for businesses. And it turns out that we're going to carefully read the words of the contract is also very bad news for businesses, as we'll see in the next case. So this is Beatty, and as I say, it wasn't good news, but shortly after Beatty, there's another case, Rodriguez versus Instagram, that very, very similar to Beatty, except in this case, the words of the contract are completely unambiguous, and they count heavily against thinking that the change is enforceable. So let's take a look at Rodriguez versus Instagram, and just to give you advance notice, this case is decided in the opposite way from Beatty, despite what look like facts that go along with Beatty and are even more decisive than Beatty, because the contract in this case is not ambiguous. You read it and you say no reasonable person reading that contract would think that Instagram was going to make the changes it makes. So let's get the facts out. This arises from right after Facebook buys Instagram. Like Facebook buys Instagram, and when it buys Instagram, it changes Instagram's retroactively updatable contract with its users. Right? The old term, the pre-Facebook Instagram contract disclaimed ownership rights in the content users post. The Instagram made a point of this. Instagram was saying, look, your intellectual property rights in the photos and content you post, those are yours. You hold those. We don't make any claim on those. All we ask from you, right, is down here, a non-exclusive limited license. We'd ask for you a non-exclusive limited license to do the things we need to do with your post to run Instagram. So Instagram says, look, we're going to have to do some things with your posts, move them around, edit them a little, right? Delete them, modify them. We're going to have to do some things though to those to run Instagram. And you give us the right to do those. Non-exclusive, limited to what we need to do to run Instagram. That's it. All the other stuff, all your other rights you got, right? And they made that as a marketing point of Instagram. right? Your stuff is your own. Now, when Facebook buys Instagram, they rewrite the retroactively updatable content and they change it in what looks like an unimportant way. Facebook says, look, nothing's changed. We disclaim any ownership of your content. You own it, we don't own it. But they changed the license agreement. Okay. They changed the license agreement. They say, but you give us a transferable and sub-licensable license to use your content with no explicit limitations. And they added a waiver of liability, which we discussed earlier. And of course, we won't worry about that. We're just going to worry about the license to use your content without limitation. So it's transferable, right? That means they can transfer, they can transfer the right to use what you post without limitation to a third party. So, and so that they can license it, transfer it and license it to third party. So what does this mean? It means you have as a practical matter, you gave away all the rights in your post. Instagram, Facebook, Instagram can do whatever it wants with them, right? Because they can sell them, they can sell the right to use them to third parties without limit, right? So they took away everything old Instagram promised. Old Instagram promised you have you really hold the intellectual property rights to your post. And Facebook took that away, not by saying you transfer the rights to us, but by saying you give us a license that we can give us the right to license the use of your post to others without limit. Yeah, you still hold the rights, you just license them all away. Right? Makes no difference. You don't really have any control. Right? That is the difference. That's how it arose. And Rodriguez, the case gets going because Rodriguez used Instagram to promote her business, right? Rodriguez ran a business. She put photos up on Instagram to run her business. And it was when she originally decided to use Instagram before Facebook bought it, she read the Instagram contract carefully because it was very important to her that she retain her intellectual property rights to her post, her photos. And so when Facebook bought it and updated the contract, she read that one again carefully. And to see if they'd taken away her intellectual property rights, she reads the license agreement. She says, I don't like that. And she sues, claiming that Instagram reached the original, that Facebook, and when it retroactively updated its contract, didn't have the right to make that big a change and take away her intellectual property rights in her photos. Right? So our question then is, the whole question in the case is that new license term enforceable? And we've got the same test. Same three-part test. Let's run through it in the case of Rodriguez. Type of transaction. Court makes the same point. Just like the New York Times, just like the bank in Beatty versus Bank of America, same clause in the new Instagram contract. We can change anything we want. So if we follow Beatty, this in itself is a breach of the obligation of good faith and fair dealing. What about the reasonableness of the business practice? Well, this is a huge change. Right? We take away intellectual property rights that original Instagram before Facebook had guaranteed as part of their marketing. Why use Instagram? Because you get to keep all those. Now we come in and take them away, right? That requires conspicuous notice, which Instagram didn't give. So this looks bad for Instagram, and the words of the agreement are also bad for Instagram. Right? Let's make it clear. In the original pre-Facebook. Right, so imagine Rodriguez reading the original pre-Facebook contract. Did she read that and think, well, at some point, Instagram may change that and take away my intellectual property rights because I'm giving them the right to make unilateral changes? Would she think that? And my answer to that is absolutely not. Why? Because not only did the original contract say that users retain their intellectual property rights, Instagram made a point of that in their marketing. Why use it? Because we let you keep your intellectual property rights. So she's not going to read that and think, oh, gee, in the future, they may pull the rug out from under me and take away my intellectual property rights, right? So much unlike Beatty, where the language was ambiguous, this language says, gee, you wouldn't read that and reasonably expect them to stab you in the back by taking away your intellectual property rights. So if you think about Beatty, right, Rodriguez should win, hands down, easy, even easier than the Beatty case because of the words of the contract. Rodriguez loses. Rodriguez loses. I quoted in the slides so you'd have it handy, the language of the court. It's easier on the video if we turn to a summary I've given of this argument, rearranges it a little bit and makes it a little easier to follow. But I wanted you to have the original words in the slides. Here's the argument reconstructed. So the court says, Rodriguez had the right to cancel the agreement. Remember when we discussed Beatty, I said, noted just in passing, there's no cancellation clause in Beatty, right? So Rodriguez had the right to cancel the agreement. Cancellation would mean she's not subject to the new terms. So the original contract would govern, and cancellation and its consequences, right? So, okay, you're canceling, and here's what happens to your intellectual property when you cancel under the old contract. And so she could just cancel and walk away. Right? We'll come back. This is a critical question. I just noted here, we'll come back to it. So the court says she could cancel. She knowingly consented to continue under the new terms. She admit, she did read the contract, right? She read the contract. And then she says, okay, I'll continue under the new contract. So the court says, if she could get out because of the cancellation clause, she read the contract and said yes to it, where can there be a breach of good faith, a failure to respect a reasonable expectation? She knew what to expect because she read the contract. That's the court's argument. Right? So the court says the cancellation clause makes all the difference. Right? That makes all the difference. That is why. So there are two things, right? The cancellation clause and the implicit assumption that she could walk away. Now let's think about how real is it that she can walk away. One problem with the case is that it doesn't consider the real plight of consumers. Rodriguez can't just walk away from Instagram. She has all her photos on all her photos and promotional material on Instagram. That's where her clients know where to find her, and that's how they follow her and communicate with her and she with them. She can't just take that all down and try to move it to some other platform. She'll lose in a large amount of business. If she survives the move, she'll lose a large amount of business. It is no realistic opportunity for her to walk away. But the Rodriguez court just ignores that, right? There's the lawyer myth that, well, she can cancel, so she can walk away. Yeah, technically speaking, legally, she can cancel the contract and she's out. But practically speaking, from a business point of view, she can't. So you wonder whether the court is being realistic about the role of contracts in business. And that we can take that point about being realistic about the role of contracts in business and to give it a more legal turn, because if you think about it, what happens to the reasonable expectation, good faith doctrine under Rodriguez at all? It's gone, right? The doctrine was designed to protect consumers like Stephen, Beatty, and Rodriguez. Right? That's its role. We emphasized that earlier on in the videos. Here we have a consumer that can't walk away, right? You would expect the reasonable expectations, good faith doctrine to protect her. But under Rodriguez, it doesn't, because once you add the cancellation clause, then according to this argument in Rodriguez, that's all irrelevant, right? In Rodriguez, there is no protection from reasonable expectation, the obligation of good faith, the requirement to respect reasonable expectations, just wiped out as soon as you put in the cancellation clause. And that can't be right. Rodriguez has got to be wrong, right? It would just eliminate the requirement of good faith, respecting reasonable expectations. All you need to put in is a cancellation clause. And you can't, and you see the problem in Rodriguez, right? She needs the protection because she can't walk away. So it's wrong to take away that protection, right? And it's just, and what can't be that putting in a single clause would do that. Okay, but okay, that's my view, right? And I'm pretty sure that's right, and I imagine it will work out that way eventually. But right now, we have Beatty and Rodriguez, and the conflict between the two cases is undecided, and you certainly see the Rodriguez decision reflected in contract practice, because look at the New York Times. Right? They put in a cancellation clause for their consumers. After Rodriguez, you saw more and more of these cancellation clauses, right? This says, I'm sorry. This says we can change, we can update any way we choose. And this says, if you don't like it, you can cancel. That is the current best practice in writing online agreements. So this is where, on our look at reasonable expectations, good faith and retroactively updatable contracts, this is where we have to stop, because the cases haven't taken us any further than this. There is a good deal of proposals to limit cases like Rodriguez from commentators and law professors, and similarly in the European Union. But in terms of US common law actual practice in the cases, the two cases are what we have. All right, that finishes this video. I will see you in the next.